Hello, 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 everyone. He's doing, yeah, I don't know. Hi, my name is Ty Sigely. I'm the executive director of Common Ground and a visiting professor of history here at Hamilton College. Thank you so much for coming to the second Common Ground event. To all of you here in person and for those of you at home zooming in, welcome. This is our second Common Ground event. Last month, we hosted the Secretary of Agriculture, Tom Vilsack, and the Republican chair of the Agriculture Committee, Representative G.T. Thompson. Mark your calendars for future events. On the 1st of November, we will host an event on the U.S. energy system. Dave Banks will be one of our panelists. He was the chief strategist for the Republican side of the House Select Committee on the Climate Crisis. And Jason Grummett is the chief executive officer for the American Clean Power Association. On November 6th, we will host an event called an Energy Transition Pathway with two former directors of the Environmental Protection Agency, Gina McCarthy and Christine Todd Whitman. And finally, on December 4th, Common Ground will host two former members of Congress, Florida Senate candidate and former Representative Val Demings, who was on President Biden's short list for vice president, and former Senator Roy Blunt from Missouri. So Common Ground is designed to explore cross-boundary political thought and complex social issues. Common Ground brings highly respected thought leaders, like we have today, to the Hamilton campus to participate in small classroom dialogues and large event discussions. Topics intertwined with the college's curriculum are chosen to foster critical thinking and holistic examination of difficult and often contentious national and global policy issues. And that's our goal tonight. Our faculty and staff who supported this event deserve a shout out, including Rob Martin, Catherine Doran, Kabul Mansour, and the Common Ground team, Katie Stewart and Kim Ritchie. Thanks to all of you. And the college is grateful to Mary Helen and Robert Morris, class of 76 and parents 16 and 17, Eve Niquette and Charles Poole, parents in 20 and 25, and Lori and David Hess, class of 77. Their support is indispensable. In my short time at Hamilton, I've been so impressed with how many and how much alumni support we receive. Tonight is a great example. Our moderator, Mike Grygiel, conceived and organized the panel and convinced these extraordinary lawyers to come to Central New York. It's my honor to introduce Mike, and he will introduce our panelists. Mike Grygiel is a 1979 Hamilton College graduate and parent of a 1923 graduate. He co-chairs the National Media and Entertainment Litigation Practice Group of Greenberg and Torig, a global law firm with more than 2,400 lawyers. His legal practice focuses on representing news and media organizations in First Amendment matters. Beginning in January of 24, Mike has accepted a part-time adjunct faculty position at Cornell University's Law School First Amendment Clinic. Thanks again, Mike, and the floor is yours.
Thank you very much. I appreciate that gracious introduction, Professor Sedgley, and I welcome everyone here. I'm happy to see such robust attendance at this evening's Common Ground program. I'm going to introduce the panelists moving from my near left to the far left. First, Eric Olson, the former Solicitor General of Colorado, now in private practice with Olson Grimsley in Denver. Eric argued the case for the state of Colorado in the Supreme Court that we're going to be talking about tonight, 303 Creative v. Elenis. And he also is no stranger to the U.S. Supreme Court because he clerked for Justice John Paul Stevens at the court. To Eric's left is Hila Keren, who is Associate Dean and Professor of Law at Southwestern Law School in Los Angeles. Hila wrote this fascinating piece called Separating Church and Market, the Duty to Secure Market Citizenship for All, that was published in 12 University of California at Irvine Law Review, page 911 in 2022, the year before 303 Creative. And I think this article predicted certain things that eventually we all saw come to pass. So she is an expert in this area. I highly recommend this piece to you. To Hila's left is Dale Carpenter, who is a professor who holds a chaired position in constitutional law at SMU's Dedman School of Law. Dale is an expert in the First Amendment, and he co-authored an amicus, which is a friend of the court brief, that was submitted on behalf of the petitioner in 303 Creative, a woman named Lori Smith. At the end of this, we will leave time for question and answer in a topic that's dedicated to exploring some of the limits and dimensions of free speech. We hope that the students here in attendance will feel free to add your voice to the mix. So just to help contextualize the case and frame the issue, some of you are probably familiar with a case called Masterpiece Cake Shop. And this was a case that came out of the Denver, Colorado area in 2018. And there was a baker named Jack Phillips who did these very creative, expressive wedding cakes. And he refused to serve a gay couple because his claim was that to do so, he would have to infringe or would suffer an infringement to his right of religious liberty because he objected to gay marriage as a matter of fundamental conscience and religious belief. So he was charged with violating Colorado's anti-discrimination law known as CADA. So Eric, can you explain what CADA is, what its purpose is, and what it's supposed to do?
Sure. CADA is a basic civil rights law that says, among other things, if you open your business to the public, you're what's called a public accommodation, then you need to make sure that that is open to every member of the public, regardless of your protected characteristic, be it gender, race, sexual orientation, gender identity, et cetera. So CADA is Colorado's civil rights law.
And that portion of the law is known as the accommodation clause. And there's another dimension to this called the communication clause. So maybe you could tag on with that a little bit.
Sure. The communication clause just says you can't advertise that you discriminate. Just like you can't turn someone away from your restaurant because of the color of their skin, you can't have a sign that says whites only in your door.
Okay. So in the Masterpiece Cake Shop case, the court decided that on administrative grounds. It felt that the claimant, Mr. Phillips, had not been treated fairly during the Colorado administrative law process because there was animus or bias against his religious rights. So the court never reached the constitutional merits of the religious liberty exemption claim. Justice Thomas wrote a concurrence in the case that professed the belief that in addition to a religious exercise claim, that there was a very interesting free speech aspect to this. And he said, in future cases, freedom of speech could be essential. So what Justice Thomas was saying, I know Mr. Phillips was arguing that for him to have to bake a gay wedding cake, otherwise be found not to comply with CADA, violated his religious liberty, but there's something about baking a cake that is expressive and involves an exercise of a communicative ability that falls within the free speech realm, and people should think about that going forward. So after that opinion was handed down, Hila, what happened next?
So lawyers really take clues very well. But before I start talking about it, I want to, in the name of free speech, acknowledge the sign that was hanged right now above us that reads, my rights are not a debate. And I want to say for myself, I'm not debating the rights tonight. I'm here to protect the rights tonight and to speak for them. And that's part of free speech. And I commend the use of free speech in this kind of a way, because it was exactly about silencing the people who are going to be hurt by this decision that the entire case was. So going back to Masterpiece Cake Shop, as I said, lawyers, and I litigated for many years, know how to read clues, and that was not even a clue, it was hiding in plain sight, right? And I want to add that Justice Thomas wrote it, but guess who concurred, agreed with him, and sided with him that there is a serious free speech issue here in Masterpiece Cake Shop? Justice Gorsuch. So fast forward a few years, Justice Gorsuch is going to write for us a case about the free speech in the same issue, but he already, by assigning him the duty to write the decision, everybody could have known and should have known that it's going to land in a way that it landed because he already agreed. But for the lawyers of Masterpiece Cake Shop, that was a very limited victory. Their client, the baker, won. However, they were in court not only for their client. What they wanted to achieve is a very wide right of business owners to discriminate against clients that they disagree with who they are and what they are. In other words, to discriminate. And they didn't get it. Masterpiece Cake Shop did not say any of that. To the contrary, Justice Kennedy, the same justice that gave us the Obergefell recognition of same-sex marriage, was very careful to say Colorado and Masterpiece Cake Shop should not have been hostile to Jack Phillips. It's a debate whether Colorado was. I'm not saying they were. However, Justice Kennedy also wrote in Masterpiece Cake Shop that the principle of businesses open to the public remain open and cannot get exemption from our anti-discrimination law stands. He writes it clearly. So they have not acknowledged, lawyers, the Alliance Defending Freedom, who's going to be main player tonight in our conversation, representing, did not present it as a loss, but it was a loss for them. On the principle, they did not manage to create the first case in history in which businesses will be exempted from the duty to serve everyone in the market. This is a big organization, the Alliance Defending Freedom. They have a lot of money, and they put their hats together how to overcome this mini victory that was a larger general loss. So they had devised a strategy that I actually recognized and noticed before 303 Creative became a famous case. It was a baby case. And what I have noticed is that there are cases around the country in which businesses in the wedding industry are starting to reject LGBTQ clients. And what was weird to me is that the language in the cases was repetitive. I recognized the same arguments, the statements of the businesses. Everything was uniform. And then I realized that what the Alliance Defending Freedom is doing is that they are initiating, and this is very important, they are the initiators of the litigation around the country that is all wedding industry businesses rejecting LGBTQ clients, and they were very strategic about it. They chose where to litigate, and they chose to litigate in jurisdictions, in states where they knew that they're going to win, which is the more conservative, what we call red states, but they also purposely took some of the cases to states like Colorado, knowing really well, because they represented the baker from Colorado in Masterpiece Cake Shop, right? So they knew well what Colorado is going to decide about another case. So that's how they planted 303 Creative in Colorado. They planted a case that you may care more about in New York, which is still pending. So there is a case of a photographer in New York. They know they're going to probably lose in New York, right? So we kind of know the ground, but they also planted cases in the conservative red states. And their goal was never what the states are doing. They had one goal: to repair what happened in Masterpiece Cake Shop. They knew that now at the Supreme Court, there are more conservative justices, so they have the majority, and they were trying to navigate their way back to the Supreme Court to reopen the litigation in Masterpiece and replay it, do it again, right? A do-over, because they did not succeed. And this time, how to get the court to actually pick the case. We need to kind of understand that the Supreme Court is picking about 60 cases per year, but there are hundreds of cases that want to be heard, right? So the court is kind of choosing, and it's really hard to be accepted. It's like applying to Hamilton or applying to another fancy school, right? Your chances to get in are limited. And so to appeal to the Supreme Court, take my case, they really wanted to lose some of the cases at the state level. That's why we saw a case in Colorado hoping to create disagreement between courts of appeals in the circuits. So predicting that they will lose some and win some. And then they will have disagreement between circuit courts. Once you have disagreement between circuit courts, then the role of the Supreme Court is to settle it. So the motivation of the Supreme Court to take the case again is really, really high. So that was the kind of re-litigation effort. And at the same time, they also continue to represent clients in cases that they did not initiate, but rather defended businesses that actually discriminated. So they had a florist that refused to serve same-sex couples to do their wedding. It was a very sad case because these were her clients all the time. These were people that were buying flowers from her all the time. When it got to the moment of their wedding, she didn't want to do that. So the ADF wanted the Supreme Court to take that case. The Supreme Court said, thank you, we don't want to take the case, right? So they didn't give them the opportunity to the do-over. But we have dissenting justices, and I'm returning now to Justice Gorsuch and Justice Thomas were against the decision not to hear the case of the flowers. They already wanted the case of the flowers to use the new majority and do a do-over on Masterpiece Cake Shop. That didn't work, right? So now we are in this spread all over the country. I'll read to you we have litigation in Arizona, litigation in Kentucky, litigation in Minnesota, Wisconsin, Ohio, Colorado, Virginia, and New York. That was the spread.
And let me interject here, Hila. I do want to make known that I very assiduously tried to get a representative from Alliance Defending Freedom on the panel tonight. I have been on other professional panels discussing this case with people from ADF, and despite my repeated invitations, importunings, entreaties, they were all declined. So it wasn't that we excluded them from trying to be a part of this discussion, but let me move a little bit and
just a closing sentence on this so people can understand. This plan that I'm sharing with you right now just succeeded. That's how 303 Creative arrived at the Supreme Court after several circuit courts said what they said. Some said you win, some said you lose, and that gave an opportunity to the new majority of the Supreme Court to now do what Justice Thomas and Justice Gorsuch wanted them to do with the flowers and take the case. So the Supreme Court taking the case already told us a lot about what's to come.
Sure. So fast forward, as part of this orchestrated litigation campaign strategy that Gil is describing, that produces 303 Creative. Where the petitioner is named Lori Smith. She owns a website design business called 303 Creative. And from there, Dale, I would ask you to describe the facts of the case, what her argument was, why Colorado's Anti-Discrimination Act could not be applied to her business and compel her to, as she framed the issue, speak in a way that is prohibited by the First Amendment. And I think it would be helpful for the students to understand what the compelled speech doctrine is.
Yeah, so describing the facts of this case are a little bit difficult because there were no facts of the case. And in this following sense, Lori Smith did have this business, a website design, and she wanted to go into the business of wedding website design and offer it to couples. But she didn't want to offer it to same-sex couples because she has a view of marriage that does not include same-sex marriage. So she didn't want to do that. She didn't actually extend the business to wedding websites until she thought, I'm going to be investigated, I'm going to be complained against by the state of Colorado, given its history, including the Masterpiece Cake Shop history that Hila just described. So I'm going to file what's known as a pre-enforcement action. Before there's any investigation or complaint, and before I'm fined and have to hire lawyers to defend myself, I'm going to get some clarity on my rights, which also should not be debated. So she said, we're going to go ahead and do this. And the question will be, I suppose the first question would be, whether she has standing to offer this case, to bring this case. There is a doctrine in the Supreme Court that says if you have a credible fear that you will be complained against, you can bring a case, and she successfully argued that she had a credible fear. After that, her claim was, the government can regulate me in discrimination. I can't put up a sign that says no gays. I can't refuse to serve gay people or Black people or transgender people or anyone else, but I can refuse under the freedom of speech not to create expression that I disagree with. In her case, it was based on her religious beliefs, but it doesn't have to be based on religious beliefs. The freedom of speech protects very controversial, unpopular ideas, and with good reason. So she said, if I am forced to make these wedding websites for gay couples, I will be creating expression. And what she does in creating these websites are classically expressive activities, she argued. They include things like writing up a narrative of the couple's story, using her own words and her own narrative in consultation with the couple. Presenting graphics that she designs, photographs, maybe videos, and so forth. It's not just a matter, by the way, of, say, telling people who look at the wedding website where the wedding will be and what time it will be and how you register on, say, at a department store. It's very, very substantive. It presents a view of marriage, she said. The state of Colorado in this litigation actually stipulated to a lot of very important facts about this creative expression. And the lower court, where we can talk about those in more detail if we want to, but I think they can be important. But the lower courts in this case actually said, you know what? You're right. The state of Colorado is forcing you to create expression. That is content-based regulation of speech, but the state can meet its burden of showing that it's allowed to force you to create these wedding websites because it has a really strong, good reason to do so, to allow gay people equal access to goods in the marketplace. And this is the only way they can do it because you're the only one who provides these services, the particular wedding website services that you propose to provide. So she loses in what's called the 10th Circuit at the level just below the Supreme Court. She takes the case to the Supreme Court, and the basic argument is I cannot be compelled to speak. The doctrine that the Supreme Court has adopted for about 80 years now is that the freedom of speech necessarily includes the freedom not to speak. That includes the freedom not to be compelled to create speech, which is exactly what she argued in this case. And that's where I think the court ultimately agreed with her ultimately in the decision. I agree with Hila, and we can get into this more. I agree with Hila that Justice Kennedy said in his Masterpiece Cake Shop decision, a lot of very positive things about the power of states to prohibit discrimination. There was also a lot of language in Justice Kennedy's opinion that suggested that businesses cannot be required to express things that they disagree with, and that some things we don't ordinarily think of as expression, like making a cake sometimes, could be expression that the businesses that do raise First Amendment issues that the court may have to resolve in the future. So that issue was left open, not by Justice Gorsuch alone or by Justice Thomas, but by Justice Kennedy and a majority of the court. So I think that's where we ended up where we're at.
Okay, and you, Dale, submitted a friend of the court brief in support of Lori Smith's compelled speech claim.
Yes.
Why is she right, in your judgment?
Well, so I think that kind of goes back in part to the stipulation. So the state of Colorado, this was not under Eric, but the state of Colorado agreed with Lori Smith that the services she proposed to offer were expressive in nature. And they were expressive in nature in part because what she was proposing to do was write up this original narrative that I talked about, expressing the story. She was going to provide images and she was going to provide film and so forth. Those are classic examples of expressive activities, even if they're in the context of business. So that was one. A second was that the state of Colorado and Lori Smith stipulated that she was going to create her own message about marriage through the creation and the offering of these wedding websites, including a traditional view about marriage, which many of us, including me, disagree with. But the state agreed that this was part of her message and that it would be obvious to customers and others who saw the wedding websites that in fact she was involved in the creation of this speech. So for those reasons, it seemed to me, at least, and to others, I think, and ultimately to the court, that this was a case of compelled speech. And the fact that it occurred in the business environment doesn't change completely the calculus about the applicability of the freedom of speech. So just think about it. The freedom of speech often takes place in commercial environments. When you think about buying books, when you think about going to the theater, going to films, when you think about buying video games, all of these things are protected by the First Amendment. If you engage in speech, if you create expression, even with a profit-making purpose, and even within the commercial context, you are still speaking and your activity is still potentially protected by the First Amendment. Now, there are a lot of other complicated issues to discuss, I think, in this case, and I think there are some closer calls, but the notion that what she was proposing to do was expressive, it seems to me, was fairly clear. The issue was, to me, what was Colorado really trying to regulate here? Was it her act of discriminating, which is not protected expression under the First Amendment, or was it substantially burdening her freedom of speech and her expressive activity, which is protected by the First Amendment? And then we come into a different discussion.
Let me turn back to Eric, and I'm going to frame this next question in a way that does not allow for much common ground, but in the interest of stimulating discussion, Eric is the Solicitor General of Colorado who had the responsibility of defending the application of CADA to Lori Smith and her website in the Supreme Court. Why is her argument, and by extension, Dale's amicus brief, wrong?
So for two reasons. The first is that Colorado was in no way, shape, or form regulating her speech. She said in oral argument that she would not sell the exact same expression to a gay couple, even though she would sell it to a straight couple. And that means, from our perspective, that she is choosing her customers rather than changing her expression. And that all Colorado is doing is saying, we regulate the conduct of sales. She can say on every website she sells, marriage is between a man and a woman. What she can't do is say, I'm only going to sell that to you because of who you are, but I'm not going to sell that to you because of who you are. So our view is we are looking at the conduct, and no matter how expressive it is, it doesn't matter. She has total control over her expression. What she can't do is discriminate as to her customer, and we view that's what she's doing. The stipulations present a really challenging issue. In my view, I part ways with Dale. I don't think they address this issue of attribution. Of course it's expressive, but that doesn't answer the question. And in looking at how we try to solve this problem, we view that our interest as a state is first and foremost ensuring fair and equal access to our public marketplace, making sure that everyone belongs, that no one has to pick up the phone and call a business and say, do you serve people like me before I come? That our job is to make sure that if you get the benefits of being open to the public, of doing there, that you can sell whatever you want, say whatever you want, you just have to sell and say it to everybody. And so that's why we think Dale is wrong. And the second point I would say is that what is expressive, once you have the government deciding how much is expressive or not, some of you have heard this in our brief, we talked about it, you know, Subway calls the people that make their sandwiches sandwich artists, right? Is your turkey sandwich expression? Probably not. But it just illustrates how difficult it is once you get in the realm of saying expressive businesses are exempt, can discriminate, what that means, and who decides. And I actually think it's a much more challenging problem to have a government regulate, decide whether you are sufficiently expressive, if you will, and so whether or not the law applies to you, than it is to say we're going to regulate conduct, even if the conduct is selling expression.
Okay, let me come back to the distinction that Colorado was making here. And I'm certainly want to hear Hila's take on this as well, but just to be clear, Jack and Jane walk into Lori Smith's business and say, we want this website. And it's very customized, it's very creative, sophisticated design graphics. And the message they want is that only marriage between a man and a woman is genuine. And you say that's okay.
Yeah.
As long as when Jill and Jane come in, they won't be turned down if they say, we really love this website and we want the exact same message.
Correct.
Doesn't that in some ways, and Justice Alito, I thought I detected some annoyance at that answer during oral argument. He seemed to say, isn't that just a tiny sliver of an argument? And my understanding of what he was saying there is, if you allow that to happen, a website designer offering commercial goods and services in the general marketplace, to say only, have a business that says only marriages that are valid are between a man and a woman, doesn't that go a long way towards undercutting and maybe even arguably eviscerating the purposes of Colorado's anti-discrimination law?
Not at all. And I would answer with an example and then strong agreement with Dale. The example is, that we talked about in oral argument, is you can have a Christmas store that just sells Christmas items. They don't need to sell holidays of all faiths. They can just sell Christian relics, or if Santa Claus is Christian enough, but they can just focus on Christmas and not have to sell other things. But what they can't do is say Jewish and Muslim customers are not allowed. We're not going to sell them to you. And it is offensive to some to see a website that says a marriage is between a man and a woman only. But under the First Amendment, that is what we have to permit, to allow for a robust debate. You can have simultaneously in our culture Black Lives Matter t-shirts and All Lives Matter t-shirts, even though people on either side of the divide find those statements offensive. And what is important, though, is regulating the conduct of sales, saying anyone, you can't turn people away because of who they are, no matter what you're selling. But it's the question of, yes, does it undercut the ease with which, does it make some people who are protected under Colorado's Anti-Discrimination Act feel uncomfortable? Of course it does. But that happens in a society that has a robust First Amendment. But what we don't want to have do is the harm that comes from not just being told, I disagree with you, but the state gives me permission not to serve you. You're not allowed in my restaurant. And that's a very different kind of harm that we're regulating against.
And Hila, what's your take on this distinction between the message in the product being offered as distinct from the status of the customer requesting the service?
So my clear opinion is with what Colorado said. The market has to remain open for everyone, and all the beautiful expressions for everyone and all the freedoms should happen in the public square where they are supposed to happen, and where people have a chance to answer those arguments. But I also want to say that other than being in the debate regarding Lori Smith and her rights on the side of Colorado, which I obviously revealed from the beginning I am, I also think that this is not the right or only the debate. You know, I think that you guys can kind of argue about her rights, but it's a little bit of a navel gazing and very narcissistic exercise, because it's really like, once you think about it as the freedom of speech, we are already agreeing that this is about her. And I do think that just this framing is very much part of the problem, because in the way I explained earlier, when businesses like her are being organized by a larger group that is speaking through their mouth and using their voices in this kind of strategy, and they go to court on behalf of this pure freedom of speech in an empty room, as if there is no one there. So the battle is presented as if Lori Smith is a creative person that wants to speak or doesn't want to speak. And Colorado is an awful state that tells her what to say. And this is within the freedom of speech. But what's missing to me is we can debate all day long about her rights, but I don't want to talk only about her and about her rights. I want to say it's not only a question of the freedom of speech. What about the freedom of someone to go out and buy goods and services in the market without fearing that any second or third business might have a freedom of speech that takes away their freedom to participate in the market? So there is something about me that told you guys from the beginning that resents the framing of this is just the freedom of speech. At the very minimum, it should be freedom of speech of one person against the freedom to participate in the market as a full citizen of the market without the threat of being humiliated by others that approve you or did not approve you. This is a lot of power to a business owner organized by a conservative movement, right? Not just her. So speaking like it's her and her rights is already putting her in a position of the victim. And we are humans. We automatically go for the victim. And it's really easy to imagine her as the victim of Colorado. What Colorado is doing here is trying to protect the real other victims in the story, that because of the strategy of going to courts pre-enforcement, were not invited to the discussion of their own life. So this is all theoretical. She never was in the wedding industry, and many of the other providers were never in the wedding industry. And as Justice Gorsuch wrote in the decision, but she worries. Okay, she worries. And I don't agree that it's only a standing question, but that putting it aside, there are other people right now worrying a lot about whether or not they're going to be refused or not refused. Do they need a green book from the 50s to navigate which businesses are friendly, which businesses are not friendly? And we'll talk later on, I think it's coming, who are the groups that are threatened by that? It's not only the LGBTQ community, it's larger than that. But what I want to say, we don't need to debate only whether she's right or not. We need to actually say, even if she has some kind of an argument, well, where's the human being on the other side? What is it going to do? Okay, so we removed Colorado from the game, right? Colorado lost. I'm very sorry that Colorado lost. But the day after Colorado lost, that means that Colorado can no longer supervise what's going on in the market. So everyone that is against everyone can start harming people. And those people, and namely same-sex couple in this litigation, but it's wider than that, were not in the courtroom. So you're talking about free speech without the voice in the debate. That is really, really important. And to me, and I'm not a free speech scholar, but I taught myself a lot of free speech because of this issue. The value of free speech to me is what we do, that we talk about the ideas and we hear all the opinions about it. But guess what? in Masterpiece Cake Shop in the litigation, when there was a real couple and their mom was with them in the shop, and there was a human being and there was a victim in the courtroom, Justice Sotomayor, who's supportive of equality in the market anyway, but she, in oral arguments, went all the way in about the rights of the couples and how humiliated they are. And everybody could see that. They had faces, they had names. The mom wrote in the newspapers about the feeling of entering a shop and being rejected in this kind of a way. But what the Alliance Defending Freedom was successful in doing is just like removing them from the debate and keeping it as one creative person against one evil state. And that made it possible that, to the point that even Justice Sotomayor during oral argument, no one, even her, said, hey, but what about the people that are going to be harmed by all that? What about the humiliation? Now, she fixed that, and she wrote in the written decision really what was missing from the hearing. But this was not missing in the hearing of Masterpiece Cake Shop. That was intuitive. We are, as human beings, intuitively sympathetic and full of empathy. And so when we had a victim, we had empathy for the victim. When someone strategically removed the victim, we sided, or a lot of people can see, oh yeah, she has a point, she's expressive. So to a certain degree, I want to say, I don't care, because I want to be able to protect other people. She's not the only one in the room.
I want to come back to one of the fundamental line drawing points that the decision raises. And my understanding, Dale, of your.
Well, there's a lot to respond to in what
Okay.
I just heard. A lot.
And have at it.
Okay. So let's just start with what Eric said. The first point I believe he raised is that the state of Colorado would say that Lori Smith can affix one label to one customer's website as long as she affixes the same label to the other customer's website and doesn't draw a distinction on that basis. She can even send an anti-gay message, and that would be okay by Colorado because the First Amendment protects her expression. I think that's right, but I don't think it captures the full scope of what's happening with this particular expression. She's not just affixing labels to websites. She is writing original speech. She is expressing what is in her mind, and necessarily is doing so in a way that, if the state of Colorado can regulate it, invades her mind and requires her to speak in a certain way. There is no one-to-one comparison that you can make. It's like apples and oranges comparison of one of these wedding websites to another based on the stipulations that we had in this case. And there was an attribution that was stipulated to in this case that citizens would understand, the viewers of the websites would understand that it was in part her speech. So I don't think that fully captures what's going on here. The second thing I would say is that Eric pointed out that it would be awful for the government to decide how much expression is enough to earn First Amendment protection and how much discriminatory conduct relative to that expression would be involved, and we don't want the government deciding that. Well, I have news for everybody. The government is going to decide that question either way. Either the state legislature is going to decide that question, or the courts, in protecting our First Amendment freedoms, are going to decide that question. And here's the thing, that is not a new question. The freedom of expression extends not only to the speech that we're engaged in right now, but it extends to things like conduct that is expressive. There are difficult lines to be drawn. On this, Eric and I are in full agreement. There are difficult lines to be drawn. There are edge cases that will be difficult. I happen to disagree in Masterpiece Cake Shop that the baking of a cake is expressive. I thought that was more conduct than expression. Not in this case. This is actually an easy case of expression. A couple of points that I believe Hila made. One is that in this case, there was nobody sort of representing the potentially discriminated against customers in the state of Colorado. I fully agree that there are very strong interests on both sides. The court actually acknowledged that there is a compelling governmental state interest in protecting people from discrimination. And if this were a case where a business was just saying, no gay people, no Black people, no transgender people, no Jewish people, or whatever it happened to be, nothing in this court's opinion would protect that kind of discrimination, nor should it be protected. It's just the expressive acts, not the conduct of targeting someone solely based on their identity. So as long as the business owner, the speaker, is objecting to the message that the customer wants the speaker to send, that's protected by the First Amendment. But if the business owner is objecting to the status or identity of the customer, that is not protected under this opinion as I read it. Furthermore, I think this opinion is actually pretty clear, and we can get into this discussion if you want to do so. This opinion is actually pretty clear that it's only a narrow band of expression that will be protected. Customized, tailored, expressive services and goods are protected. All of those parts are very rare in the marketplace. Very, very few businesses will be able to claim this kind of protection. And we can talk about that more. The other point that Hila made is that ADF and other groups have a kind of strategy of bringing these cases, and there's no doubt that they have a strategy of bringing these kinds of cases. You can read great stories about this. One is in the Washington Post. One is in the New Yorker, I think was in the last week or so, talks about ADF's strategy. Well, I have some more news for you. It's not just ADF that has this strategy of bringing pre-enforcement actions that don't have other parties present in the case. Every single cause lawyering movement that I know about, political lawyering it's known as, has used these strategies. They carefully curate who their clients are. They advise their clients what messages and what things to say to put their case in the best possible light. They have PR shots of their clients. You think about the strategy, for example, that the great Justice Thurgood Marshall used for the Black Civil Rights Movement. It was extraordinarily thought out, very much curated, very careful. When you think about the great Justice Ruth Bader Ginsburg, the women's movement that she spearheaded in the ACLU Women's Rights Project in the 1970s was extraordinarily careful in only bringing male claimants to the court to presumably get the court to agree with those claimants when she was pressing them. The LGBT rights movement, I wrote a book about this phenomenon. You didn't plug the book, but I'll just plug it myself.
I'll plug the book. It's a good book.
Thank you. Available at fine bookstores everywhere, called Flagrant Conduct. And it tells the story of how sometimes movements don't even choose their clients. They get their clients chosen for them, but then they take over and carefully curate the facts. The same-sex marriage movement is a perfect example of litigation that was brought carefully choosing the most sympathetic plaintiffs imaginable. Lesbian couple raising special needs kids, veteran from Afghanistan, a man whose partner had died and didn't have his marriage recognized by the state of Ohio, the Obergefell of Obergefell, in Obergefell versus Hodges. All of these are very common tactics of movements. I don't think we can single out one group or one cause for that kind of political lawyering.
Okay, Hila, I can see you want to respond.
Yeah, I'm boiling here, so I will kind of. Yes, you are actually beating on a straw man. Yes, pre-enforcement was used in history, but all the examples that you just heard about were people fighting for their own rights. They were not asking to harm others.
How's that different from her?
Because
Lori Smith has rights to free speech.
Well, I listened, and now I'm going
Okay.
to answer that Lori Smith requested exemption from anti-discrimination law, which means Lori Smith requested a right to discriminate, which means that by definition, Lori Smith is asking to do something to other human beings. She may win, she may lose, but it's not comparable to people fighting for women's rights and doing pre-enforcement, or people fighting for rights for racial minorities, because all those people are fighting for their own rights without suggesting that once they win, they will have the freedom to harm others. The recognition of same-sex marriage did not take anything from people who are heterosexuals, and it was not aiming at them. It was fight for rather than fight against. And here the ADF is, my problem is not with the ADF orchestrating pre-enforcement. My problem is by the ADF using pre-enforcement method to achieve elimination of the voice. And thank you for the other point of, oh, the people were talking on their behalf. Why can Laurie Smith have blonde hair and blue eyes for the public to see on YouTube and everywhere, and there are no eyes for the couples she wants to actually discriminate? So I adore Eric for his heroic fight in court, but I don't think it can replace ever human beings in the court being there and with their body and with their soul, letting the public see who is really going to be harmed by all that method. So I just really not an answer to anything. And thank you very much that she serves some other gay people. That really reminds me other arguments, some of my best friends and all those kind of arguments, because seriously, you kind of selling to gay people, that means that you are not doing status-based. For all I know, in same-sex marriage people who are involved are gay people. So only them are doing same-sex kind of marriage. So this is something that is history repeating itself. That's not the first time people are saying. Some of my best friends in court. So in the 50s and 60s, when people were trying to prevent, for religious reasons, by the way, the mixing of the races, the owner of the business said, oh no, some of my best clients are Black people. I do serve them. I just don't want them to mix with the white people. So I let the white people dine in and I serve the Black people take out. And this is a concept in anti-discrimination law and public accommodation law known as limited menu. And once you do limited menu, you cannot excuse it's not status-based, because you do give limited menu. So if she's willing to do a website of a gay entrepreneur to promote the business of the gay entrepreneur, that doesn't make it okay to say, but I'm not gonna do a website for your wedding, because that does mean that some people are gonna walk around being able to consume some goods and services, but not the other goods and services. And it can't stop at weddings, because once someone refuses to acknowledge the gay marriage, what do you think, that they're going to sell them something when there is a child in the family, when they celebrate the 10th anniversary? So the same problem of having a family that is based on the foundation that is really something that there is resistance to. We start from the wedding because that's where they chose to start. But family reunion, they will say, oh, but I don't recognize that there is a family here, right? So whatever the occasion will be. So it's really unstoppable. And the last point, and I'll finish there because I don't want to take all the time, but it's really to respond to your plea. She is expressing what's on her mind. The problem, that was stipulated in advance. And then there was oral arguments. And in oral arguments, Justice Kagan, I believe, one of the liberal justices, asked the lawyer of the Alliance Defending Freedom, what will happen if your client will not need to express her mind, but rather a same-sex couple will come and say, our best friends had such a beautiful wedding website that you designed for them. We want exactly the same. No new text, no new graphics, don't even change the color scheme. We love everything. Just change the names. Will your client do that? And in the oral arguments on behalf of the Alliance Defending Freedom, in open court, there was a new fact born and then ignored later on in the decision, where the statement of the Alliance Defending Freedom was, no, my client will not do that. Even though there is zero new design or graphics or colors or anything. It is, I'm quoting now, it is because it is the announcement of the marriage that she objects. So how much about the design it is.
So one of the most essential.
My job is getting
freedom-
easier, as you can all tell.
True. One of the most essential freedoms that the LGBT rights movement has used over the past century, I would say, especially the past half century, has been the freedom of speech. It's been the freedom of speech because when gay people and bisexual and lesbian people and transgender people argued that they should have full equality, as I have argued over time, it was said that they were harming people through their speech. They were promoting dangerous ideas that were dangerous to children and to others, that were destructive of our society. The reason that movement succeeded, the reason that it was able to organize and has had the persuasive power that it has had over time, is that we have a very open conception of a two-way First Amendment, where we don't just favor the causes we believe in, but we favor the causes, we allow speech for the causes that we disagree with. That has been absolutely essential. Most of the country thought that gay people were not just immoral, but dangerous and predatory and infectious and every other kind of thing. And over time, gay people were able to argue that we are like others and we should have rights, including anti-discrimination laws, which I also favor, including same-sex marriage, which I filed a brief on behalf of in the court. And those rights are possible because we have the freedom of speech and a broad conception of the freedom of speech. I will say this: if we back off now on a particularly libertarian conception of the freedom of speech, there are forces waiting right now out there, and they are acting now in state legislatures to take away those rights and freedoms to speak. Book bans, bans on drag shows, all kinds of freedom of speech kinds of bans are passing. We are going to want the very expansive freedoms of speech that have been protected now and that do protect people that we strongly disagree with. It would be a tragedy for us to back off on it.
Okay. I do have one provocative question that I'm going to come to, but I want to just hold for a minute, because another dimension of this opinion that I think many people find troublesome is, and Eric, I'll ask you this: can Justice Gorsuch's majority rationale be limited to messages that object to gay marriage, or does this spill over into a whole other range of protected characteristics identified in the Colorado Anti-Discrimination Act? In other words, if I am a wedding website designer who is opposed to interracial marriage, can I refuse to serve that couple because to do so would violate my free speech rights? What if you're someone who is a eugenicist and you don't think people with disabilities should get married? Where do we draw the line here?
So in my view, the court doesn't draw the line, but before I get to some of the specifics, I just want to say, agree very much with the central premise of what Dale just said, of the importance of a robust First Amendment. But where we disagree is I don't see this implementation of the First Amendment as part of that robustness, because it creates the power to turn others away and is used to prevent our state, our government, from protecting its citizens, from creating an open marketplace for everyone. So some agreement on the basic premise, but I think where we go, there's disagreement. And on this question of what's at stake, I will say, as we thought about how to position this case before the Supreme Court, we didn't see any limiting principle on the free speech arguments on the other side. And we very deliberately wanted them to own the consequence of what they would do if they ruled to the other side, as we expected, given the writing on the wall or neon signs flashing, however you describe what Hila talked about in the history. And much of the argument was spent talking about how there wasn't a limiting principle here. And it was not met with analytical rigor by the justices in the majority. They sort of assumed it away. And so every time a question would come up about race, they would say, well, race is different, but they never said why. Or they would talk about a statement in the Obergefell decision. They said, well, quote, decent and honorable people have different views on this issue, and they would stop. And I would say, no, you need to keep reading. When decent and honorable people have different opinions, but when the power of the state is seen as favoring one view, that's too far and violates our Constitution, which is why we're saying this is a constitutional right in Obergefell. And so I worry. I don't think this court tomorrow would say 6 votes for people to turn away mixed race couples from wedding services. I do think they have set in motion a mechanism for mischief and harm that other courts in other situations will use to greatly expand the power to discriminate in a way that, as Hila said, with very asymmetrical costs and benefits, without taking into regard what it means for all of us, what it means for Lori Smith to be able to get the services she needs from someone who doesn't want to sell it to someone who has a religious views. But that all of us, what makes our country wonderful, and we haven't lived up to our promise, but what makes our country wonderful is that we create this marketplace, this community square where we aspire to have everyone feel like they belong and can fully participate. And what this set in motion, I fear, will lead to an erosion of that, particularly in communities that aren't large with lots of service providers. I grew up in rural Appalachia. Justice Sotomayor, as Hila mentioned in her dissent, talked about the couple in the South that had to go to a different funeral home to have a funeral. They've been together 20-some years, and they were turned away and their funeral canceled because the funeral home refused to host services for a same-sex family. And it's not just in Denver, where I live, but it's our whole country where there are real harms and tragedies that people are forced to deal with because of the mischief this decision unleashes.
Okay, so I want to ask one more question. I think this is going to be provocative. In your brief, Dale, that you submitted, I do read this as overtly articulating certain libertarian strands in different places. And what I will say caught me up short was the paragraph on page 26. And I'm going to read it so people can hear it. Same-sex couples looking for website design services do not confront the pervasive dignitary assault and material burden encountered by Black people trying to find places to eat and sleep in the South of the 1960s. Instead, same-sex couples need only click the next website appearing in a lengthy list generated by an instantaneous Google search. So do I understand that position to say whatever dignitary harm is occasioned by Lori Smith turning you down if you're a gay couple looking to have a website designed is constitutionally acceptable because you can go down the street and there's a lot of market alternatives available?
No. So I think that's with respect, I think that's taken out of context. So what our brief argued is that here we have core expression. Now, you can disagree with that, but our view was there was core expression here, the creation of speech. And given that fact, given the fact that she's actually actively engaged in this, and it's not any kind of cookie cutter sale of a product or a service, you can't justify restrictions on her. You can't justify compelling her to speak based on dignitary harm. That is actually an unexceptionable principle, I believe, in the First Amendment, and I'll tell you why. And this goes to actually to something also that I think Eric said. And I think you might be right about this not being limited to just the same-sex marriage context. So we have a First Amendment that, according to the Supreme Court and the lower appeals courts, protects the right of literal Nazis. I'm not talking about people who cut in front of you in line and you call them a Nazi. I'm talking about literal Nazis marching in uniforms with insignia and everything else, marching in a neighborhood of Holocaust survivors, proclaiming their message. The Supreme Court has said for a very long time, and the ACLU argued for this, that that is constitutionally protected, because even though you take great offense at it, there's a dignitary assault involved clearly for those people and for everybody else, as far as I'm concerned. Even though that's present, the First Amendment makes sure that that protection has to occur and that speech has to occur. And the best antidote to that speech is counter speech, which in the case of the LGBT rights movement has been extraordinarily effective against anti-gay speech. We're not at the end of this story. And I actually have some of the concerns that I think Eric just expressed. So I am concerned that if this decision is overread and too much stuff is regarded as both expressive and customized, some courts could take this decision too far. So my view is that appropriately applied, this decision limits what is to be considered expressive and what also is to be considered customized and individualized products and services, meaning, and the Supreme Court used these words, that only a small number of businesses, the vast array of businesses, will not be protected by this expressive protection under 303 Creative. And so we're not going to get the wholesale denials of people based on their identity that some of us do fear could happen. So I don't think that's going to happen, and I think it will be, I think it'll be overruled in the Supreme Court if it happens. Because I will add one thing: Justice Gorsuch's name has been, I would say, invoked in vain a number of times, but Justice Gorsuch wrote a decision in Bostock versus Clayton County that gave us the broadest expansion of LGBT rights protection from discrimination for both gay and transgender people in the history of this country, when he said that the protections of federal law for employment discrimination, for example, extend to LGBT people. He's the one who wrote that decision, and he got a majority for that decision, and on textualist grounds, usually regarded as a conservative ground for a decision. So I think he's in some ways expanding freedoms in both directions. And what we've had happen over the past 100 years or so is that anti-discrimination law has not been static. Anti-discrimination law has expanded over time. Its sort of empire, its reach has expanded over time to cover new kinds of spaces, new kinds of businesses, and to cover new categories of protection. That's been recognized by the Supreme Court. Because of that, we face the prospect of ever-increasing conflicts with the freedom of expression. And those have to be resolved one way or the other.
Okay, Hila,
I want to respond.
we're getting
fir-
short on time now.
First of all, yeah, I'll try to be quick. There is a reason the First Amendment is called the First Amendment. And it is because it's not the only amendment. If it was the only amendment, we would not have described it as a First Amendment. And you know which amendments came after the First Amendment? The 13th and the 14th and the 15th. And so to really define clearly common ground and the second straw man in this conversation, I do not agree with the idea of we let horrible ideas be in the public square and it's going to be good for everyone because freedom of speech is really good. It's true. And Eric already agreed, and I'm going to agree too. all horrible ideas and good ideas should go to the public square. That's First Amendment. And then there is 13th Amendment. And that says when you are in the market, $1 in the hands of one of us should be worth like $1 in the hands of another one. And in the marketplace, this is the principle of open for all is a principle of the Constitution. So when the majority in 303 Creative is saying Colorado has no power to overcome the Constitution, it's a sliver of the Constitution. It's the First Amendment. But what is on the table is also the part of the Constitution that actually opened the market for all. Public accommodations laws that are in charge of equality are really in charge of that piece of equality, not shutting down the conversation. In fact, when you are rejecting a client for whatever crazy reason you may have, the client can't answer. There is suppression of speech rather than a speech. If someone goes to the public square and says awful things about same-sex marriage, I can go to the public space and say beautiful things about same-sex marriage. But if I am rejected because I am involved in a same-sex marriage, I have no recourse. How can I answer that? There is no real float of ideas that is the purpose of the free speech. And anti-discrimination laws may be slightly expanding a little bit of common ground, but you know what's expanding even more than anti-discrimination law? It's free speech. Free speech in the last decades is really getting out of control in the sense of when corporations are donating money, that's speech. You can speech by how you sell. You can speech in a variety of ways that were not acknowledged before, that are really outside. So there is an expansion of the freedom of exercising religion, mixing of state and church, and expanding the freedom of speech. So I don't think that it's really that. And to give credit to Bostock, yes, was I happy to read that Justice Gorsuch, credit to him, read the word sex as inclusive of sexual orientation and gender identity? Yes, I agree with you. But you know what else he did? He marked the territory inside Bostock and said, but I'm not saying anything about the exemptions of the religious people, inviting actually the next battle for exemptions. The same technique that was going on in Masterpiece case.
Okay.
The First Amendment and the 14th Amendment apply to government action. In this case, in the 303 Creative case, the government action here is the enforcement of the anti-discrimination law against the individual's rights of freedom of expression. The 14th Amendment is a protection against government action violating equality principles. Lori Smith is not a governmental actor. The basis for the claim against her is an anti-discrimination law. And another thing that I hope is common ground is this. In the event of a conflict between the Constitution, the First Amendment, and a mere statute, the Constitution prevails.
Okay, well, we're short on time. I do want to open this up to questions from the students, but I'm going to invoke the chair's prerogative and have the last word on all of this. And I think maybe this will lead us to some common ground. As someone who is fortunate enough to make his professional livelihood defending free speech in the First Amendment on behalf of news media and organizations, I nevertheless find this decision very troublesome. I'm worried about the socially dislocating effects that it may have if certain things come to pass and certain line drawing doesn't keep it properly cabined. What I found very powerful about this was Justice Sotomayor's penultimate paragraph in her dissent. And I'm going to read it to everybody. And here's what she said. I fear that the symbolic damage of the court's opinion is done, but that does not mean that we are powerless in the face of the decision. The meaning of our Constitution is found not in any law volume, but in the spirit of the people who live under it. Every business owner in America has a choice whether to live out the values in the Constitution. And my understanding of what she is saying there is that the law, I think she's taking the long view. And she's really making the point that the law may be, for now, what 6 people wearing black robes who work at 1 First Street in Washington, D.C. say it is. Nevertheless, all citizens have a choice to live their lives informed by the Constitution's values, which gives that document its real meaning. That is true not of just of business owners, it's true of everybody in this room, including the students who are gathered here today. So if you want to frame her message, I think, in terms of the fabulous Broadway play about the namesake of this college, I think what she's saying is, to all of you young students here, go out and take your shot. So we can end there and take questions.
Oh, okay. I thought there would be more hands. One question I do have, is, see that I think, should, I think,
Speak into the mic a bit so
Yes,
we
thank
can
you.
all hear you.
I think what, Ms. Karen and Mr. Olson to a lesser extent talked about, was kind of what, to what extent should the Supreme Court kind of take into account like any harm that may subsequently occur from the decision? And I guess I'm just kind of curious as to whether, for all three of you, whether court cases like this in general with the Supreme Court should be decided based solely on the context and the merit of the case, or rather what any societal impacts may be.
That's a huge question, so whoever wants to tackle it.
Well, I think that the court should have and always does take things that, whether they say it or not, the court always, as in charge of justice, is taking into account what the decision will make, what kind of consequences there will be to the decision. And the fact that there were stipulations in this case, meaning facts that were agreed upon in advance, was actually used as fig leaves for this court to actually kind of release itself from this kind of a duty. And this is what Justice Sotomayor, in her very forceful dissent, was trying to tell them. Look, this decision is going to take us to a segregated marketplace. And she talks about the experience of the late Justice Ruth Bader Ginsburg traveling in a car and seeing windows of stores saying no dogs and no Jews, and asking her parents about it. And she really told a lot of compelling other stories, among them the funeral story, to remind all of us that decisions have consequences and that we need to think about it. And so I think these consequences that you're referring to were very much on the mind of the minority and are documented in the dissent and laid out. And Justice Sotomayor talks at length about the humiliation and reminds everyone it's really not about the cake. It's really not about the burgers. It's not about the movies. It's about the humiliation that someone experiences in a devastating way individually, but also as a community, that a full community learns that they are not welcome in some places. And all that is forcefully written in the opinion of Justice Sotomayor. So at least 3 justices who voted against this decision were really thinking about the harm, were very clear about the harm, but this is where law touches politics, and the majority is 6-3 in a way that is perfectly aligned with the question who appointed each of the justices.
Well, I will say Justice Gorsuch's opinions in particular are almost the most non-consequentialist opinions that I've read from a single justice on the court. And so in a sense, I kind of agree a little bit with Hila that he doesn't really think about the consequences too much. I do think there are consequences no matter what the court does.
Yeah.
And harmful consequences no matter what the court does. So we could describe those. I mean, for the business owner, for example, if you are required to express these messages, you have a choice to make of either abiding by your overruling your conscience or facing financial ruin. I mean, that's your consequence. One baker who failed to provide a single cake in Oregon to a same-sex couple faced a fine of $180,000 for one cake in that state at the initial trial level. So there are consequences either way, but Justice Gorsuch actually doesn't pay a lot of attention to them. And that's actually characteristic also of the Bostock decision that I mentioned earlier. So a lot of people argued in that decision that you should not extend anti-discrimination protections as he did to LGBT people. Why? Because there will be a lot of litigation. What do we do about bathroom access? What do we do about people who change their gender or transition during their employment? What do we do about this and that? What do we do about religious freedom and all of the objections? He said, look, I'm just reading the law, and the law that says you can't discriminate on the basis of sex necessarily includes sexual orientation and transgender status. So I'm glad he did that in that case and didn't take into account the consequences, the harmful consequences that a lot of his allies wanted him to take into account. On the other part of the consequences side, if I'm right, most of the things that we buy in the marketplace are not going to be protected. So when you think about most of the things you do, you get employed, you get health care, you rent an apartment, you buy a house, you get a line of credit, all those things, those are not expressive acts by any of the businesses selling them, and they're not going to be regarded so by the court. And most of the products we buy, whether it's in the grocery store or the pharmacy or wherever it is, are not expressive sales in anybody's imagination. At the farthest margins of the most aggressive argument, there's no argument there. And even if they are expressive, like books are expressive and films are expressive and art is expressive, if they haven't been made for the customer in particular, that is, if they're not customized, they're not protected under 303 Creative. Very few of the things that we actually buy in the marketplace are going to be covered by this decision, and nobody can be denied solely based on their status. So I would consider those things among the consequences.
Just two quick responses. I wish I shared Dale's optimism about how this case will play out in practice. And a big asterisk to Justice Gorsuch's approach, I cannot hold in my mind the way in which he approaches tribal right cases at the U.S. Supreme Court, which I view are very consequentialist. He looks at the big picture. He understands the history and harm beyond the pleadings in that case to place the plight of the American Indians in context, and is a huge advocate for that community and to right the historic wrongs that they faced. And to have him be so empathetic and so big picture oriented in that realm, and then look at what he does in Bostock or 303 Creative or wherever, where he sort of says, whatever, this is the opinion, and not grapple with it. It both gives me hope that maybe his empathy will grow over time, and makes his failure to grapple with those issues, particularly in constitutional cases where you're looking at these hard questions with a limited set of documents to interpret, his failure to do so here is a very deliberate choice that is, to me, very sad.
So just on the expansion of it? Is it?
Let's have another question. Looks like we have a lot. Great.
So I wanted to talk about sort of like the pretense for the whole thing that creating a website is inherently expressive. And it's like, Dale, you mentioned that like creating a website is creating speech. And I agree with you there that it is creating speech, but I almost feel like it might be the couple's speech as opposed to the website designer. So in this case, like this couple, unless they are web developers or people with the skill set to create a website, they have no other avenue by which to voice this particular type of speech. And like they can't produce it themselves. So I feel like by getting rid of their right to purchase this website, you are in a way advocating to curtail this couple's speech. And I feel like it poses a really important question. That is sort of the question that I'm trying to get at, which is how do we decide whose First Amendment rights take precedence here? Should it be the designer or should it be the couple that is trying to articulate their speech through the designer?
So that's actually a really good question. And I don't think that we have a binary choice. Is it the web designer's speech or is it the customer's speech? In fact, it is a collaboration of both. Obviously, it's the story of this couple that wants to get married. Obviously, they are the drivers of this decision and this decision to buy and so forth. But it's also, and this is again part of the stipulations, it's also the fact that Lorie Smith is the one that's giving voice, that is actually expressing, that is writing out the story and creating the narrative in a way that is presentable and sympathetic as possible to this couple and their family and friends and everything else. So I think the answer is that it's both. And if it's at least partly Lorie Smith's speech, she can't be enforced to collaborate in something that she objects to. That's the basis of the First Amendment argument. The other thing I would say about this is that I think it's true that both the customers and Lorie Smith have First Amendment rights. Both of their rights are rights as against the government under the First Amendment. So Lorie Smith has the right not to be forced to create speech, but the couple has a right from the government, has a right not to be squashed in their expression of their own marriage, so they can go seek other people's services and so forth. But what the couple doesn't have is a right to demand that Lorie Smith platform their speech or host their speech. The court has decided that in a number of cases. For example, there's a famous case called Hurley, in which the Supreme Court said that there was a First Amendment right for parade organizers in Boston, the annual Irish parade, not to have to include a contingent that they didn't want to include. It happened to be a gay contingent that was going to march behind a banner that said, "We are gay and lesbian Irish people," and so forth. And the court said that was a public accommodations law, by the way, an anti-discrimination law. The court said the First Amendment rights of the organizers of the parade not to have to host the speech of that private contingent prevailed over the anti-discrimination law. So that's the issue I think that we face with 303 Creative.
Yeah, I see
But it
I see
never
a real
happened.
difference.
It
though.
never happened in history,
Yeah.
never happened in history that the Supreme Court allowed a business owner to do that.
So
So
that's true.
this parade was classified as public accommodation, what was parade in the public square that I keep talking about. Really, that's where the freedom of speech belongs. And Justice Sotomayor says in her dissent, you are doing something unprecedented. And basically the majority is saying, well, we're just applying the former cases. But this is the first time in history. In the 60s, when a business owner was making similar argument, the Supreme Court back then said, this is frivolous. This is frivolous.
That's where the business owner said, we won't even serve Black people in our restaurant. That is not a 303 Creative decision afterwards. And I will also say this. I think what Hila says is true. This is the first time that these principles have been applied to a business in the public marketplace, but there is nothing sacrosanct. There is nothing that makes the commercial marketplace immune to constitutional principles. As I said earlier, all of us on this panel would agree the New York Times can sell newspapers for a profit, it hopes, and it doesn't matter that the New York Times is making a profit or selling products in a commercial marketplace.
Not the
I'm
profit.
quite finished.
Not the profit.
So it's in this commercial space that we still have the application of free speech principles. We don't lose those things.
The problem is not the profit. The problem
Or the
is
commercial marketplace.
the problem is holding oneself open to the public, benefiting
You don't have
from
to.
serving.
I think we have time for one more question.
We'll continue this.
I just have a clarifying question for you, Mr. Carpenter. Right before the question session, when we were discussing, or when you guys were discussing the First Amendment and the 14th Amendment, you said you would hope that in a situation where you're talking about the Constitution and a near stipulation, you would hope that we would return to the Constitution. What were you referring to as the near stipulation?
The mere,
I think you said
Near
statute.
stipulation.
It's a constitutional statute. I think,
We're-
Dale,
we're
you're
mind-
saying was that
this is
where
a
there's a
conversation we
conflict-
had before the
Yeah,
panel.
before,
No,
not
no,
before-
no,
this
no.
is
At
before
the end of the panel, when you were talking about
At the end of the panel before the questions.
where there's a conflict between the.
Oh, I see,
Constitution
I see.
And a statute.
Sorry.
Yeah.
I'm sorry, I misinterpreted your question. So one of the points that the court made in its decision is that in the event of a conflict between a statute and a principle of the Constitution, it is bedrock constitutional law that the constitutional provision prevails.
But what, in this situation, what were you referring to as the statute?
So the statute I'm referring to is the Colorado anti-discrimination law.
Okay.
And so the claim is, and this is disputed, and I know Colorado disputes this, but the claim is that the Colorado anti-discrimination law in this particular application would violate the First Amendment. And I think the argument that if that's the case, the First Amendment would prevail is not open to serious question on the court.
But
Yeah,
I guess I.
Eric, last word, and then we're at time, so
I-
last word.
I guess at a high level, I agree. However, I think as we think about the democracy that we want to share with each other, that is welcome to everyone, that when you have 6 justices say statutes and legislation that were passed by a democracy using the democratic process cannot be enforced because of the Constitution,
Like the bans on same-sex marriage.
we need to have great care in what we allow for our democracies to do as opposed to what we allow for our courts to
Right.
decide.
So my husband actually agrees with both of you, I'll say, on this panel. But same-sex marriage was a case where most of the states had laws on the books banning those recognition of those marriages. And the claim was that the 14th Amendment was in conflict with those statutes, and the court, thank God, agreed that those statutes violated the 14th Amendment, which is why we're here.
Okay, we're at time. Thank you, everybody. Thank you, Professor Sedgley, for working with me. Thanks our wonderful panelists who traveled considerable distances to be here with us. So, and thanks to all of you for being here.
And thank you. Remember that just because we're common ground doesn't mean we all agree. Thank you all for the panel. One more round of applause for the panel, please. And there are feedback, little things that we have back there. If you do a little feedback card, appreciate it. Thank you.
So I don't disagree with him.
Yeah,
often.
but the constitutional.